During prosecution of a patent application in Europe, decisions regarding territorial coverage are predominantly made at the filing stage and at the grant stage. At the filing stage, applicants decide if they want to pursue a European patent application at the EPO or national patent applications filed at the various national patent offices. Once a European patent grants, a decision is then made on the countries in which the patent should be validated. In future, a further decision, if unitary patent protection is desired, also needs to be made. Unitary patents are available based on already existing European patent applications. Let's look at the considerations owners of European patent applications may wish to make at the acceptance stage of a European patent application before considering if there is merit in changing patent filing strategy in Europe. We've prepared another video that deals with the pros and cons of obtaining unitary patent protection in some detail. Procedurally, unitary patents are obtainable on request after a European patent has been granted. For companies who routinely file European patent applications and who may wish to, or at least contemplate obtaining unitary patent protection, there's consequently no need to change filing strategy to obtain unitary patent protection. Just stick with EPO filings. Important inventions, though, may warrant changes to the filing strategy for divisional applications. Whilst the European divisional application and its parent are linked by a common priority date and a common filing date, they are otherwise considered separate applications. This means that a validation or opt-out choice made on one patent does not limit choices on the other patent. It's therefore possible to keep a parent or divisional patent with a narrow claim scope opted in the jurisdiction of the UPC, or to even pursue unitary patent protection on its basis, whilst the other of the parent or divisional patent with a broader scope of protection may be validated nationally in a traditional way and then opted out of the jurisdiction of the UPC to avoid a central revocation attack. With regard to long-term strategy, if the jurisdiction of the Unified Patent Court is to be avoided, then this can be done by opting the European patent out in the 7-year transition period. Opt-out status is retained for the life of the patent, so that an opted-out patent avoids the Unified Patent Court for life, even after the end of the transition period. After that, filing national patent applications is the only way of avoiding the jurisdiction of the Unified Patent Court. One further point to consider is that, with the creation of the Unified Patent Court and the Unitary Patent, the various UPC member states have also considered the national double patenting provisions. Noteworthy are the changes that will come into force in France and Germany once the Unified Patent Court opens. They are very similar. In particular, for opted-out European patents validated in Germany, a parallel German national patent granted after the UPC agreement comes into force will lose its effectiveness in as far as the scope of protection overlaps with that of the European patent. That's not the case if the European patent has not been opted out. By not opting out, a route for double patenting protection in Germany is therefore opened. The same is true if a unitary patent is obtained on the basis of the European patent. For important cases that are likely to be litigated, separate national patent filing in Germany may therefore be desirable. This is particularly so if one of the main features of the German patent system, the separation or bifurcation between infringement and validity proceedings, is to be maintained. The UPC rules of procedure do of course also provide for bifurcation, but it is not expected that bifurcation will be widely used in UPC proceedings.